Good afternoon. This is cause 2023-1186 in the interest of Brian Bermudez Jr. All parties and witnesses, please raise your right hands to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, ma'am, please state your name and your relationship to the child.
Stephanie Vaughn Russell. I'm Brian Alex Bermudez Jr.'s mother.
All right, and representing Attorney General, State of Texas.
Andrea Perard.
Court will note that the non-custodial parent is Brian Alex Bermudez. Mr. Bermudez was personally served on March 2nd, 2021 at 8:16 a.m. at 701 North San Jacinto Street in Houston, Harris County, Texas. And he was further notified of this Zoom hearing by certified mail, return receipt requested, which was delivered on April 11th, 2022. He has not filed an answer or made an appearance. Is that correct, Ms. Perard?
That's correct, Your Honor.
We'll proceed by default.
Thank you, Your Honor. At this time, the state would call Ms. Russell. Ma'am, in regards to conservatorship, you have no objection to being named joint managing conservators with Mr. Bermudez. Is that correct?
That's correct.
With you designating the residents with a geographic restriction to Harris County and contiguous counties. Is that correct?
Yes, ma'am.
Now, for the court's record, Mr. Bermudez is currently in the Harris County Jail, correct?
Yes, ma'am.
And he's in jail for one of the charges is actually assaulting you. Is that right?
Yes, ma'am.
And also for a parole violation. Is that your understanding?
Yes, ma'am.
And so while he has a pending charge of assault against you, on the record, you have no objection to being named joint managing conservator with him and having a standard possession order for the child, as you have no issues with him having possession and access for the child. Is that correct?
No, I don't.
Okay. Now, in regards, you are, however, still asking for a non-disclosure finding in such that he won't have your address and information now or in the future. Is that correct?
I don't mind him knowing where I live. I don't, but I would rather meet up with him when it comes to my son. When we come to handing him to him or him giving me my child, I'd rather meet somewhere public.
Okay. And so that is why in the pickup and drop off for the standard possession order would be at the Walmart on I-10. Is that right?
Yes, ma'am.
Okay. So are you okay with your address and information being in this court order?
I don't mind. I do not mind.
Okay. Your Honor, at this time, we did have a non-disclosure finding in the case in the court order due to the pickup and drop off. So up to the court to determine whether you would like to maintain that non-disclosure in there, also because of the pending criminal assault family member charge.
That's just, you can submit an amended order or a new order.
Okay, we will do that.
Okay.
Yes, Your Honor, thank you. Okay, so Ms. Russell, what we're going to do is we'll amend that order and remove the non-disclosure, but we will still have a pickup and drop off at the Walmart. Is that your request?
Yes.
Okay. And we understand that because he is currently in Harris County Jail, that child support and medical support are both be setting at 0 at this time since he is deemed to have no income. Is that your understanding and agreement?
Yes, ma'am.
And how is this child covered by insurance?
He has Medicaid.
We're going to order you to maintain that government medical assistance. And you are also not requesting any retroactive child support or medical support. Is that correct?
That's correct.
That concludes the order, Your Honor. I pass my witness.
All right, the court will approve the order when you submit it with the non-disclosure not included in that order.
Thank you, Your Honor. Ms. Russell, if you can, may Ms. Russell be excused, Your Honor?
Yes.
Ms. Russell, if you will disconnect from here and go back to that other room where you were in this morning, I'll have Miss Guillory make that change on your order, okay? And resend it to you via DocuSign.
Okay, thank you.
Okay, thank you.
You're dealing with Pearson, Gerard?
Yes, I am, Judge.
Ms. Daniels, please unmute yourself. All right, this is cause number 2024-6042 in the interest of Coy Pearson. All parties and witnesses, please raise your right hand to be sworn. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ma'am, please state your name and your relationship to the child.
Faith Elizabeth Daniels, Floyd's mother.
All right, and representing the state of Texas Attorney General's office.
Andrea Perard.
Court will note that the non-custodial parent is Charles Pearson. Mr. Pearson was personally served on November 9th at 4:59 p.m. He has not filed an answer or made an appearance. Is that correct, Ms. Perard?
He has not filed an answer, Your Honor. For the court's notice, he did check in this morning, and then once we went to talk to him, he had disconnected and left.
Okay, he was given further notice of this setting by certified mail, or attempted to be given further notice by certified mail, which remained unclaimed. And we will indicate that he was present earlier, but left on volition. Is that correct?
Yes, Your Honor.
All right, let's proceed by default.
Thank you, Your Honor. The state would call Miss Daniels. Ma'am, in regards to conservatorship, you're asking to be named sole managing conservator in this case, with you being the party to designate the residence with a geographic restriction to Harris and contiguous counties. Is that correct?
Yes. Yes.
Okay. And that is because Mr. Pearson, actually, there was a family violence incident on June 1st of 2020, I believe. And I'm sorry, December 1st of 2020 has received a criminal conviction and 3 years probation for that as a family member charge. Is that correct?
Yes.
Okay. And because of that, you're also asking for the Family Violence and Possession Access finding in the court order, and that any pickup and drop off exchange of possession should occur at the McDonald's on Maxey Road. Is that correct?
Correct.
Now, you have no objection to him having possession of the child or children in this case, just that it be picked up in a protected setting, correct?
Correct.
Now, how is this child covered by insurance?
Medicaid.
I'm going to order you to maintain that government medical assistance. And Mr. Pearson does have one additional child that he's court ordered to pay child support for. Is that your understanding?
Yes.
So your current medical support will be set at $50 per month beginning June 1st of 2022, and giving him credit for the costs of that and the one additional child. Your child support will be $191 beginning June 1st of 2022. Is that your understanding and agreement?
Yes.
Now you are asking for retroactive support from your date of separation, which was June 1st of 2020 up until today, the amount of $4,800. Is that correct?
Yes.
And that was based on the minimum wage presumption at that time. Is that your understanding?
Yes.
And you are also asking for your address and information to be kept out of this court order because of that family violence. And you're in agreement that Mr. Pearson's address is also kept out of this order, not because of any family violence where you were the perpetrator, but he's alleged another person has been a perpetrator of violence against him, correct?
Yes.
He's still ordered to notify you of his address information changes pursuant to this order. Is that your understanding?
Yes.
That concludes the order, Your Honor. I pass my witness.
All right, the court will approve the order submitted. Thank you.
Thank you. Ms. Daniels, you've signed your order, I believe. You are free to go.
Thank you.